Eva, let's get to property. Not necessarily your pantry, but your property. Who, in the scheme of a divorce, is entitled to claim property?
Well, at the end of the day, usually both parties to the divorce or the de facto relationship breaking down need to sort out their property arrangements. They may need to divide property, or they may simply need to work out whether they're each keeping what they brought into the relationship and how do we formalise and protect that.
Now, when it comes to that division, presumably not everyone's always on the same page.
No, often it's not agreed, and hopefully the lawyers can help them come to an agreement about it. If we can't help them, we might end up having to file some court proceedings so that a court might help them initially, and they do have some conferences at court to try and sort that out. Ultimately, a judge will make the decision if no one can agree on it.
The big thing about this is, though, and I think we mentioned this last time, that most people say the only people that benefit are lawyers, because if you're heading into the courts all the time, this is going to be a costly process. So a lot of people say it's better to settle outside. Is that actually the way, or is there more danger in settling between yourselves?
I think it really depends, probably on who has got the power in the relationship and the greater assets, who's losing more by maybe agreeing to a deal. Agreeing to a deal is always a good idea, but you want to get some advice so that you know that you're not giving up too much in coming to that agreement. You also want to protect that agreement by having it drawn up properly so that someone can't come back later and say they didn't get enough, or someone benefits later from an inheritance or some other cross lotto win or something like that, and the other party wants to come and take some more from them.
Yeah. At what point do you still have a claim on the other person?
So there are time limits to bring these claims. When you're married, the time limit starts from after you get divorced. So you've got 12 months from the date of your divorce. You need to be separated firstly for 12 months to obtain a divorce. Once you've got your divorce, you've got 12 months to file a claim in court for a property division. That's for married people. For de facto people, they've got 2 years from the date of their separation to file a claim at court or to sort it out and file some agreed orders.
And so once that has been filed in court and the next day you get a lotto win, does your ex-partner have any claim on that?
So if you've filed some consent orders that finalise your division, or you've entered into a binding financial agreement that finalises your division, and that person goes on to win the cross lotto, the other person has no claim.
So even if you're actually not divorced, as long as the property division has been lodged and settled, you have no claim.
Once it's settled, that's right. When it's still proceeding in court and it's going through that process, there could still be some argument about that financial resource the person's come into, even though that's after separation.
What about if you find out later that your ex-partner wasn't upfront about everything they had? Do you have a retro potential to claim on that?
You might have an opportunity to challenge the agreement or the decision that was made about your property division if you find out later the person hasn't given full disclosure of their information.
Okay. Now, you might, as we're having this discussion with Eva Bailey, who is a partner with Anderson Solicitors, have a specific question that you want to put forward or a comment to make. Now, obviously, she can't give you specific legal advice, but you might have had a situation that happened and she might be able to explain what was happening there or something like that. Or if you would like a little bit more information about one area of this, feel free to give us a ring, 1300 222 891. You can also text us on 0467 922 891. So whether you're a de facto couple or a married couple, you've got to establish what the property settlement, what the list is, I guess.
That's right. You need to start with working out what are the assets and liabilities that we have at the end of this relationship, those that you have accumulated together and those that you brought in to start with, and looking at that entire property pool and then working out who's going to keep what out of that pool. Does there need to be a payment from one person to the other and some adjustment? And we look at how to work that out as well.
Can you establish the property pool, or should you be going to a lawyer for that one?
I think two parties can work through a list of their assets. You need to look at it at market value, and you would benefit from some advice, but you can sit down and work out what your assets and debts are and how it might practically serve you to divide them and sort that out.
I mean, that's all well and good if a house is paid off and all of that, and so you know what the ultimate value is and you'll get half or 60-40 or whatever it might be. But if you've got a mortgage on there and liabilities associated with that, that's kind of a bit harder to negotiate, isn't it?
It gets a bit tricky. It depends, as you point out. The bigger the pool, sometimes it can be easier because there's more in it to divide. Sometimes the small pools are hard to divide. But then the big ones might be hard to divide because someone's brought in a lot of that to the relationship and they don't really want to share, a half or a reasonable division of that with the other party.
But once you're married, isn't it automatically 50-50?
Not quite. Once you marry or you enter into your de facto relationship, we still need to take into account under the Family Law Act who brought in the assets to the relationship. So that's your starting point in working out your contributions financially and non-financially into that pool. That's one of the considerations under the Act for working out who keeps what and what percentage each of you should get. So if one of you started out with 90% of the property pool and there's a short relationship, that person may end up still with a greater share of the pool at the end of the relationship because they brought in that big chunk at the start.
But if it's that case and 30 years down the track,
that might be different. That's right. The longer it is since that initial contribution, the less weight that contribution's likely to have. And then you're looking at other contributions during the relationship, financially and non-financially, into that pool and into the relationship and looking after children and those other factors.
And just a question here, what constitutes de facto? What's the time limit to establish a de facto relationship nowadays?
So that's now covered under the Family Law Act, and you need to be living together for 2 years or have a child together, or one of you needs to have made significant contributions into the relationship where it would be unjust to not consider it a de facto relationship. So it's not quite as simple as just your 2-year period anymore. If you've lived together and you have a child together, it may be considered a de facto relationship. And if you've lived together and someone's put money into your property, then you may have a de facto situation.
Okay. Michael's given us a ring. Hello, Michael.
Hi, Sonya. Hi, Eva.
What's your question, Michael?
Yeah, I've been separated for three and a half years now. I was married for about 18, and I just want to know what happens in relation to superannuation, because she's got nearly 100,000 in super.
Okay, so you've been you were married for 18 years. You've been separated for 3.5.
Yeah.
And where does the super side of things sit?
Does that get divided up either, or?
Yes, superannuation is something that we need to look at in talking about dividing the property pool. It may need to be divided. Under the Family Law Act, you can roll it into the other party's super account effectively, so that we do sometimes balance it out evenly. It depends on the situation.
Yeah, and also, how expensive is it to do a divorce?
How long is a piece of string, Michael?
Well, the divorce itself, you can do a divorce yourself or you can get a lawyer to help with it. The divorce itself is really just an ending of your marriage, and you only need to be separated for 12 months to file that application with the court. There is a pretty hefty court filing fee to pay. The property settlement, though, is something you need to do.
Is that hundreds or thousands? Or?
The court filing fee is just under the $1,000 mark for most people. There are some reductions for people in pension situations. The property settlement is separate to your divorce, though. The divorce ends your marriage legally, and it starts that time limit that I was talking about, whereby you need to then have sorted out your property within the following 12 months. Mm-hmm. So if you haven't had your divorce yet, then your time limit isn't ticking, so to speak, for that yet.
Okay, Michael, good luck with that. Sounds like it's a bit yucky. Another texter says, I have a relative going through a nasty divorce settlement. Can this be podcast, please? Well, you can certainly listen to it for 7 days afterwards by going to abc.net.au/Adelaide. Just click on the afternoons program and find the day that you are there. Now, when we assess contributions, are we talking about super there or other things?
So firstly, we talk about the property pool and working out the assets and debts and superannuation. Then we look at the contributions of the parties into the asset pool, financial and non-financial. So one person might have been working more during the relationship and they've brought more income into the relationship and thereby more super. One person might be doing more of the home caring and the parenting. That's still a lot of the times the case, and those things need to be considered. The good thing is about our law, they do now consider non-financial contributions have a similar weight to the person who's working as the person who's staying at home, if that's what two parties have worked out works for them.
Mm-hmm. Okay, so assess the contributions, and it might not all be financial. And what about future needs?
So that would be our next step in looking at the property division, the future needs, people's income and earning capacity, their health, and those kind of things are taken into account. So if one person can't work because of some health issue, they've got a greater future need because they can't earn an income and rebuild their assets that they're looking at dividing.
Okay. And then you have to work out who gets what.
That's right. So basically work out what there is to divide, look at how we divide that under contributions and future needs, and then look at overall who keeps what and is that just and equitable in that situation? Does that work out in a practical sense as well?
You're listening to ABC Radio Adelaide, South Australian, Broken Hill. In the studio with me is Eva Bailey from Anderson's Solicitors. We're talking in our second part of our series on divorce and separation. We looked more generally last week. Today we're getting specific about property, and next week we'll get more specific about children because there are lots of issues around those areas. If you've got a question to ask about how to make that easier, 1300 222 891 or text us on 0467 922 891. So we've talked about the steps and the processes here, Eva. For some people, they would like to keep it out of court if possible. What are some of the things you can do to make sure that happens?
Sure. So hopefully you can have some conversations with your former partner and you might be able
that doesn't always happen,
work things through. No.
No.
Then there's other options like mediation. You can have lawyers assist you with that, or you can go to organisations, I think I mentioned last week, like Centrecare or Relationships Australia do some mediations. You can go for an arbitration, which is where not a judge but someone else who's organised like that can make a decision in your matter. Or you can have lawyers negotiate via correspondence with one another and perhaps convene a conference. So there are a few different ways to keep it out of court, and we certainly try to do that for people.
Yeah. But other than the cost of, what is the cost of a property settlement being lodged?
So the cost of the settlement being lodged is the filing fee. That depends on whether you're seeking final orders or interim orders. Usually we're seeking both, and you're looking at a filing fee of between $400 and $500 usually for your initial application. That's the court fee. When you've got a pension card, that fee can be exempt, or if you're under hardship, there are ways to potentially apply to exempt that. But for most people, they're paying that court filing fee, even to file your own one without a lawyer.
Anthony's given us a call. Let's talk with Anthony. Hi. Hello.
Yeah, hi, how are you?
Yeah, good.
Yeah, look, I'm just ringing up, and the Advertiser a couple of weeks ago, they had a case where the husband and wife, the legal bill was more than the house, was about $900,000.
Yes, I did see that written up, and that would be an extreme case, usually, particularly in Adelaide. There are probably more high-profile and expensive cases in Sydney and some of the other states, but it is a concern for us, Andrew. We are concerned as lawyers that there's some obligation on us to try and get matters dealt with where our clients still end up with something at the end. Certainly we don't want clients who end up spending all of their money with their lawyers and not ending up with something themselves. That's a very disappointing case.
David, a question, an interesting question from David, actually. Hi.
Hi. Now, mine is the opposite end. I have a female friend staying with me who lost her house after losing her job at GMH. Now, she's been staying with me a while. I understand if you live with a woman long enough, there can be legal implications of potential ownership. Now, there is no relationship other than she has my spare room rather than being homeless. Do I have to be worried about my asset in relationship to this person I'm showing kindness towards?
I think it's a good idea that you're turning your mind to it, but I don't think you have any legal concern. If she is boarding with you or renting with you per se and not having a relationship with you, then, as you say, you're simply helping out a friend and you've chosen to live like housemates and she's living in your home.
Does there have to be a financial agreement there? Because David, are you charging rent or board?
I haven't at this stage because she got completely broken when she lost her job.
So it could be argued
stage,
that you're not getting any benefit as such from this.
I'm just trying to help out a long-term friend. And, hey, we go out, when I say go out, we've gone out and just had tea together or something just because it's better than sitting at home staring at the wall. So it's a grey line, and I'm just concerned about, I don't think it's in her nature, but I don't want to find out by accident that I've created myself a time bomb.
I think that's fair enough to be concerned about it. Ultimately, there are steps to proving a de facto relationship. Intimacy is one step to proving that. Appearing as a couple and going out as a couple and telling your friends and family that you're a couple is another step. So there's a number of different factors that determine if you're in a de facto relationship. I shouldn't think that helping out a friend and living with housemates would put you at risk, but it's good to turn your mind to that and make it clear that that's not the case and that you're not in a relationship. And if people around you know that and you've got those people to back you up later, that might not hurt to have that.
Would it be wise to hand a piece of paper at this stage? It's basically going, you're a mate, you're staying here at my behest, and just having that signed in case, and would that be enough to defuse any future time bomb if it occurred?
It wouldn't be enough in terms of a binding legal document, but it might be a record of the intention of you both, which you could refer to later. So it probably wouldn't hurt to have that.
Thank you for the information.
Good on you, David. Nice to hear from you. And final question here on our text line. I'm hoping I understand this. Can you be separated, do the property settlement before the divorce comes through after 12 months of being separated? So I guess it's, can you do the property settlement before the divorce comes through?
You certainly can do the property settlement first. We often see people, because in that 12 months before you get legally divorced is usually when you need to be trying to sort those things out.
Yeah.
Some people take a lot longer because they're not in a hurry and they might have made an arrangement with the other person and they're happy to do it later down the track. But yes, you certainly can do your property settlement.
Can you do your property settlement before 12 months of separation are up?
Yes, you can. So you can do it in that 12-month period.
You can do it as soon as you separate?
Yes, there's no time limit on when you start doing that.
But there is an end date.
There is a time limit after you've been divorced for 12 months to bring the action to court. Yes.
Okay. On that note, look, one more question from Bob. Hello, Bob.
G'day, how you going?
Good.
Look, I'm just asking about family trust. I have a family trust and all my assets are in that. Does that protect, is that protecting my assets from a de facto or marriage relationship?
Not in a family law sense. The Family Law Act does have the ability, the family court, to look beyond trusts. When we get a situation where there's a family trust, we need to have a look at that trust, how it's made up, what type of trust it has. But it's not as simple as using a trust to protect your assets.
On that note, Bob, thank you for your call. We're going to leave it. Eva Bailey has been along talking to us in this series we're doing on divorce. Next week she'll be back and we'll focus specifically on children and some of the issues around children, their future needs, how you look after them through divorce. Thank you so much.
Thank you, Sonya.
Oh, sorry, turn your microphone off. There we go. Eva, and thank you for your tins that are going to go into our food bank bin as well. Eva Bailey, partner with Anderson Solicitors.